Okay, we also have Charles Coleman, a civil rights attorney, and Bob Bianchi, a criminal defense attorney, former prosecutor as well, with us. Bob, your reaction to what we just witnessed, and again, the verdict being unanimous on all 5 counts, not guilty.
Honestly, it was not surprising to me. This case was charged within a couple of days before they had the autopsies done, before they had completed the evidence collection, before they had gone through all the videos and the interviews. And at one point on the show that I host, I was actually listening to a witness, and I was asking the producer, is this a defense witness that was called out of turn? To find out it was the third victim, Grosskreutz, in the case, because multiple witnesses for the state were actually providing the self-defense testimony that Rittenhouse had actually testified to himself. So it was a very, in my opinion, strong self-defense case, especially given the fact that he was being chased, that he had rocks thrown at him, gunshots going off, he's kicked in the head, hit with a skateboard. And the prosecution's theory of the case, as a former homicide prosecutor who's tried lots of homicide cases, lots of self-defense cases, is that he merely provoked the incident because he came there with the AR-15. But you got to remember, you're in a jurisdiction where this is not an unusual thing. If you were in Jersey or New York and you saw something like this, it would be crazy, but it's not there. So the theory of the government's case to me went too quick, too fast. I've investigated homicide cases far, far, far less complex. It took weeks and months for us to finish our investigation. And I think the defense attorney's statement to the jury that this was a rush to judgment and that the actual prosecution witnesses supported the self-defense claim of Rittenhouse resonated with them.
Bob Bianchi, who is also with us, reminder he is a criminal defense lawyer, has been a former prosecutor. What do you see as the key moment in this trial that may have been a tipping point for jurors?
I like to talk the difference between a narrative and facts. As your correspondent is so eloquently reporting, we've been watching every detail of the facts, not what was being reported, speculation, not about the politics of it. And as your other guests are commenting, I want to go to that provocation. If he's engaging in unlawful conduct, I'm reading it right now, that provokes others to attack. And then there's a line in there that's very, very important. It indicates that a belief may be reasonable even if mistaken. So when Kyle Rittenhouse gets on the stand, after 3 of the government's witnesses had indicated that he was being chased, they were screaming and yelling at him, hitting him with skateboards, getting kicked in the face by jump kick man, shots being fired behind him. There were opportunities that he had to use the weapon where the people backed away and he didn't fire the weapon. To all, whether they're on the liberal side or conservative side, of trial lawyers who have ever tried cases, these jury instructions are not that unique. In virtually, I would imagine, every state, given the burden of proof and the presumption of innocence in this country, the prosecution, I know in Jersey, has to disprove self-defense beyond a reasonable doubt to all 12 jurors. How do you do that when you saw no real provocation going on, him not threatening anybody? He's taking care of graffitis, walking around with a medical kit. I think he came off as like a cop wannabe. But in the end analysis, they're the ones pursuing him. And the government's witnesses themselves were saying they were in fear for his life because of the people were throwing rocks at him and he was being pursued. He's running away. Come on. There's just not, it's not about narratives. It's unfortunate that narratives is a tail wagging the dog here. It's the facts that came out during the course of the case that showed that those narratives were in large part completely inaccurate. And so this jury did its job by looking at the facts, taking its time, deliberating over the evidence. And even though it may have been a mistaken belief, they believe Kyle Rittenhouse, under those circumstances, felt not only death, but great bodily harm. A lot of people are missing that. That could be a protracted loss or impairment of the physical body, member, or organ, what have you. And when he's down on the ground and people are grabbing his weapon and he's been threatened already and he's trying to run away and he can't go anywhere, there wasn't a real trial lawyer. I'm talking about a trial lawyer that's really tried cases, that didn't sit here and say, this is an amazingly good self-defense case. And the sign of desperation for the prosecution was when they asked for the lesser included offenses. After Rittenhouse testified, they knew their self-defense claim was going down in flames, and they were hoping, I'm telling you, this is what goes on as a trial tactic, that they would give the jurors an opportunity, instead of saying not guilty on everything, and guilty of the highest charges. They knew they had difficulty with this case, so they wanted to give them a middle ground that they could land on.
Okay, so obviously we are looking at live images right now outside the court.